even though some people call me Elizabeth. And it is certainly my pleasure to introduce our speaker, Sarah Staudt from Appleseed Center, I'll call it, to speak to us today about criminal justice reform in Illinois and about the recent major legislation that was passed. The Appleseed organization is a volunteer collaborative nonprofit organization that advocates for fair, accessible, and non-racist courts in Chicago, in Cook County, and throughout Illinois. Sarah Staudt has been working for Appleseed for a number of years and has been working in the area of criminal justice and more fairness in the criminal justice system for her whole career. She got a bachelor's degree and a law degree from the University of Chicago, and she was very active in the statewide coalition that led to the passage of the Pretrial Fairness Act last February. Now, many of you who are here and who might be listening later know that the Evanston League worked with the Illinois League last year to review the league position on criminal justice. And that was a position that was more than 20 years old, maybe 25 years old, maybe more, and was very much out of date. And the conversation about criminal justice, I think has been evolving quite a lot and in a positive way in the last 10 years and in the last 5 years. We learned a lot while we were looking into those issues, including pretrial services, issues of cash bail, issues of some prison conditions and conditions upon release release from prison, all of which were not, well, all of which may have needed improvement in a variety of ways. The Pretrial Fairness Act that was passed in February, I think, reflect major steps to make the criminal justice system in Illinois fairer. Sarah Staudt and Appleseed and others were an important part of that process. Now, this is such an important question that Sarah decided to bring 2 colleagues with her. And we're glad to have those colleagues. And that is Deanna Rutherford from the People's Lobby and Akisha Lee from the Southside Organization, or Southside Organized for Union and Liberation, I think it's called. We'll leave it to them to decide how they're going to divide up their project. They agreed that they would answer questions too, if you have questions after their presentation. So thank you very much, all 3 of you, for coming, and we are looking forward to learning more about this important topic.
Awesome. Akisha's going to start us off, and maybe Akisha, you can start by introducing yourself a little bit and what Soul does, and Dina, maybe you can do the same when we get to your part. Does that make sense? Does that work?
Yeah.
Cool. So yeah, Akisha's going to start us off, and yeah, I'm really excited to be here to talk to everybody about the Pretrial Fairness Act. Let me share my screen, and I'll let Akisha take it from there.
Perfect. So yes, good afternoon, I guess now, because it's after 12. My name is Akisha Lee. I am with Southsiders Organized for Unity and Liberation. I am the lead organizer there. My pronouns are she, her, and hers. Soul is a Southland-based organization focused on building power amongst folks who live on the South Side and the South suburbs. All of our projects / campaigns focus on increasing access to resources and decreasing oppression and mass incarceration. Some of our projects outside of this one are ACT-CCJ, which is about affirming care for trans women incarcerated in Cook County Jail. And then we have a Water for All project, which is around subsidizing water for low-income residents in Chicago. Okay. Can I get the next slide, please? All right, so a little bit about us. So we're all from the Illinois Network for Pretrial Justice. It's about 40 organizations across the state, representing 9 counties and several statewide organizations as well. Members stretch from Carbondale to Waukegan, from Rockford to Champaign. And we're here organizing around pretrial incarceration and talking about how the current system works. We're going to talk about what policy changes we accomplished with the passage of the Pretrial Fairness Act, and we'll close things out with information about how you all can get involved. Next slide, please. Okay. What I already said. So it's important to us that we have partners all around the state because it is a statewide initiative, and we know that pretrial fairness can have different feelings, whether you are in a downstate part of Illinois versus Chicago. They want to be clear that this is an issue that impacts all Illinoisans. Next slide, please. So the effective money bond. So every year, more than 250,000 people are incarcerated in 92 county jails in Illinois. 90% of them are being jailed pre-trial. And this is much higher than the national average of 67%. A majority of these people are incarcerated simply because they cannot afford to pay a money bond. So currently, when a person goes before a judge, the judge has the ability to release the person on their own recognizance or I-bond, which means they are released pre-trial and don't pay money. They could be deny the person bond altogether and incarcerate them if they think that they are not safe to be released or are a flight risk. C, they could set a money bond that must be paid to secure their freedom. Judges also have the ability to set conditions on a person's release, which it can include everything from check-ins with pretrial service officers to house arrest with electronic monitoring or EM. So just to be clear, when a judge sets a money bond, the court has already cleared that person for release. So that means the judge has legally determined that the person is not a danger to the community, and the only thing between that person and their freedom is access to money. So this is wealth-based punishment inflicted on people while they are presumed innocent under the law. If these individuals have more money in their account, they would be at home, able to work, support their families and loved ones, and able to make positive changes. Okay, this is the current slide. Okay, so the harms of incarceration. Incarcerating someone pre-trial has significant consequences on the rest of their life. Just 2 days in pretrial incarceration can significantly disrupt a person's life and set off a destabilizing domino effect, causing people to lose their jobs, housing, and even custody of their children. Fast forward to a month in jail, people lose access to crucial public benefits that they are receiving before incarceration, creating gaps in coverage for things like healthcare, Social Security benefits when they are released. And the first few days in jail are also some of the most dangerous because many people die in jail within those first 5 days. Death is particularly a high risk for those who are most vulnerable, including those who have mental health needs or folks who use drugs. Next slide, please. Thank you. Okay, so why does pretrial freedom matter? So being incarcerated makes it harder for people to participate in their own defense. People in jail are more likely to be convicted, and they are more likely to serve sentences that are longer while awaiting for trial. And some quick stats you see on the screen here, they're 4 times greater likelihood of being sentenced to jail, and they have a 3 times greater likelihood of being sentenced to prison. So the pressure of pretrial incarceration can lead someone to accepting a plea deal to simply get out of jail, a deal that they may not have taken if they were able to maintain connection with their family and friends and community. And I've experienced this personally with loved ones. And when they're released from jail, no one cares that they took that plea due to outside pressures, right? It's hard to explain. It can have permanently destabilizing effects when it comes to like finding employment after incarceration. So also locking people up who are presumed innocent is also undermining the system's own stated goals of creating safety and ensuring people come back to court. People who are in jail pre-trial are more likely to be rearrested in the future. That means jailing people is literally creating more crime. And this makes sense when we think about all the negative impacts that jail has on someone's life. and how it keeps them from maintaining positive relationships or staying connected to resources to help them succeed. The less we destabilize people by jailing them and support them instead with resources in their community, the better off we all are. So I've talked a little bit about this, but it's also powerful to hear people's story from their own mouths. So we're going to take a second to watch a quick video. Oh, can you hear it?
Okay, I think now we should be able to hear it. You hear me, right?
Yes.
I was incarcerated pre-trial for 2 months.
2 months,
3 months,
1.5 years,
simply because I couldn't afford to pay $1,500.
$5,000,
$7,500.
$25,000. I lost my home.
I nearly lost my son.
I lost my business,
I almost took a plea that I wouldn't have otherwise.
not because of a conviction.
but because of an accusation.
Our stories are unfortunately not unique.
They are all too normal.
Every year, more than 250,000 people pass through Illinois' jails.
250,000 people.
But we can stop this injustice today.
The PreTrial Fairness Act will end money bail in Illinois.
The Pretrial Fairness Act will restore the presumption of innocence.
The Pretrial Fairness Act will allow hundreds of thousands of people per year to stay in their communities.
Working,
Taking care of their family.
And accessing services while awaiting trial.
let's end money bail.
Let's end money bail.
Let's end money bail.
Let's end money bail.
And bring our people home.
Across Illinois.
Thanks for watching that, y'all. Feel free to drop in the chat if that video has brought up any feelings for you all. Like, I'm always so taken aback to hear how small of an amount of money stood between someone and their freedom. And with that, I'm going to pass it off to Sarah.
Thank you so much, Akisha. That was really great. So I want to talk about, so that video, as I'm sure you could tell, was made just before we passed the Pretrial Fairness Act, because it was talking about the Pretrial Fairness Act in the future. I'm very happy to say that it is now true that the Pretrial Fairness Act has passed, and although it's not in effect yet, it will end money bail entirely in Illinois. So what I'm going to do now is I'm going to walk through sort of what principles guided the way that this law is written and how we ended up putting those principles into practice. The bill was written, I always like to start with sort of how the bill was written. We have been working in coalition and with other organizations, 14-member organizations in Chicago and 40-member organizations statewide, been working together to craft this legislation for years and years. So from the beginning, we found common ground and common principles that we could work from and really made an effort to put those into reality in the bill. I'm pleased to say we got a lot of what we wanted. The bill is very, very close to the bill that we originally wrote, which can't always be said for a political movement. And it's really a testament to the power of our organizing that we were able to really keep these principles alive in the bill. And as a result, we have the most progressive piece of criminal justice legislation, certainly regarding pretrial freedom, that has been passed in the country. Like, there's no question that what the Pretrial Fairness Act will do in Illinois will provide stronger protections for people than anything that has happened anywhere else in the country. So let's talk about what it does. The first thing it does, and the first principle we were sort of organized around, was that money should never be a determining factor in whether someone is free pretrial. This is really basic, but it's really, really important for all the reasons that Akisha just said. What the bill does is it ends all use of money bond, all cases, everywhere in Illinois. And that makes it different actually than some other reforms that have been passed around the country. We don't end money bail just for some charges and leave it for others. Every single charge, no matter what you're arrested for, wealth will no longer be the thing that is standing between you and freedom. What's more important than getting rid of money bail, though, is making sure that our reforms actually decrease the total number of people who are incarcerated. So if we had gotten rid of money bail, but in the end we had replaced it with a system where more people get locked up, we wouldn't have achieved anything, right? And so that is really like the key principle that organized how we wrote this bill, that release from directly after arrest should be the norm, and jail should be the carefully limited exception. And if that sounds like sort of technical language, it's because it is. That's from a Supreme Court case. And it's actually the law of the land, a US Supreme Court case called US v. Salerno. It's the law of the land. That's what's supposed to happen. But we know that in reality, nothing close to that is happening right now. And the PFA is trying to really restore that balance. So what does the bill do? What do we replace money bond with? What the bill does is it basically it creates something that when we're being technical, we call a detention net. But what we mean is that we look at the whole universe of charges against people. Most people charged with most crimes will not be able to be jailed pre-trial, period. A judge will not be able to make the decision that a person should be jailed, for example, for a low-level drug case after January 1st of 2023. They must be released. And that's really, really important because we know that judges have a lot of pressures on them that often lead them to incarcerate people when they absolutely do not need to and shouldn't, right? And we wanted to make sure that our bill made clear that if you are charged with, with most offenses, with most things that people are arrested for, jail should not be on the table. So the second thing we do for very low level charges is that we create a ticket system. So for your what are called Class B and C misdemeanors and ordinances, so very low level charges, things like trespassing and public urination and jaywalking and various other things, which people absolutely do get arrested for in huge numbers. Instead of having them held overnight and appear before a judge the next day, which, like as Akisha said, even a little bit of time in jail can hugely destabilize people's lives. The Pretrial Fairness Act instead replaces that with a ticket system that says for most low-level charges, police have to give a ticket to somebody the way they would for a traffic ticket instead of taking them into custody and destabilizing their lives. Ultimately, these are crimes that no one is going to see jail or prison time for anyway, right? So all we're doing by arresting people is pulling them out of their communities and out of their lives unnecessarily, only to eventually turn around and usually dismiss these cases. So we're really trying to decrease the total amount of contact people have with the system. The last thing the bill does is, of course, it doesn't bar, we weren't able to bar jail for everyone, right? The Pretrial Fairness Act doesn't abolish jail, but it raises the standard that judges use to determine who is detained pretrial. So it really sets a very high bar and says that judges are only able to detain someone if they pose a specific real and present threat to another person, or if they're a high risk of what we call willful flight. And those standards are higher than they are almost anywhere else in the US. And I think that's very important because if we're going to taking away someone's liberty is the most severe thing that the state can do to someone, right? Putting them in a cage. And we need to make sure the standards that are used to do that are really, really high. So I love me a flowchart. So this is a flowchart of how the system basically works. So when someone is stopped or arrested by police, basically, as I said, we divide charges into two categories. Most felonies and misdemeanors, I actually did the math on this on the arrests recently, and it's about 85% of arrests are going to go into the sort of the bottom track of this flowchart. That means that one of two things can happen. The police can release them directly from police custody with a court date within 21 days, which is a very efficient way to go about, dealing with these cases, and one we hope that police will use a lot, because there's really no reason that we should be holding people overnight for what's essentially an emergency court date, when ultimately they're going to be released anyway, and they're going to have to come back to court in 20 to 30 days. Like, it makes much more sense to just say, here's your court date, show up for that first court date. But either when they show up for that first court date, or if the police do hold them overnight, the first thing that happens is they appear before a judge, and the judge knows that they're going to release them, but has the opportunity to set conditions of release. So if they want to, they can, for example, make sure they can add things like check-ins, text message reminders, and other sort of supportive services, which is what we really hope will be used the most, because what we know is that most sort of restrictive conditions really don't do much to help people and often make it actually harder for people to succeed. So then this is sort of the $1 million question, I think, in a lot of people's heads is, so what about more serious cases? What about murders? What about cases where safety is really a concern? So for a set of cases, about 15% of arrests in Chicago, they fall under this category that we call detainable. And what that means is they can go through a slightly different process than what I just described. So what are these cases? Basically, it's we call non-probationable forcible felonies, which is a big fancy legal term for the really scary violent crimes you're thinking of: murder, armed robbery, home invasion, carjacking. Very, very serious violent crimes. The second category is all sex crimes, all domestic violence, and most gun felonies, unless they are so low level that they're probationable. So those are the cases that can be subject to jail right after someone is arrested. Just because someone is detainable, though, does not mean that they're going to be detained. There's a couple things that have to happen first. The state's attorney, first of all, the prosecutor has to decide that they want the person to be detained. And that's really important. The state's attorney is the person at the beginning of the case, like the day after someone's arrested, who has the most information about what's going on, other than the person themselves, which is going to come out through their defense attorney. So the state's attorney is going to make a decision: do I even want to detain this person? Is there enough evidence that that's something that I want to do? And if so, they can file a petition and ask for a hearing in front of the court. There's a delay of about 24 to 48 hours, depending on what the charge is. And then there's what we call a detention hearing. And this really replaces sort of the we have bond hearings currently in this county that sometimes last 20 seconds, right? Detention hearings are going to be a much more formal and longer affair. They exist in New Jersey. They take about 15 to 45 minutes. So what they are is a hearing where both sides get to present evidence. The defense can call witnesses if they want to, so can the state. And the question before the court is, does this person pose a specific, real, and present threat to another person? Or do they pose a danger of what we call willful flight? And willful flight is a higher standard than just, are they going to miss court? The question is, are they going to willfully evade prosecution? I always think of this as like the Rod Blagojevich rule, like the kinds of people that you might need to like take their passports because we're afraid they're going to flee the country. That's the kind of willful flight we're talking about. We're not talking about missing court because you didn't have childcare, which is often the kind of failure to appear that's used currently to decide whether or not someone should be jailed. The court makes a decision. If they find there's no specific, real, and present threat to another person or risk of willful flight, they can release the person with conditions. If they do find that that danger exists or that there's a high risk of willful flight, that's when they can jail someone. If they do jail someone, it's jail without bond, meaning that they won't be able to post to get out, and there will need to be another hearing in order for them to be released. One of the benefits of this system, I worked a lot with our victims advocates who support this bill, is that it means that no one can sort of surprise get released. We obviously hope that people will get released from jail during the time. They will not stay incarcerated for the entire pendency of the case. But by doing it through a hearing, it means that there's process so that everybody is notified that someone is about to get out of jail, which is where like orders of protection are at play, can be really important. So the third sort of big concept we organized ourselves around is the idea that accused people should be viewed holistically, and they shouldn't have, one event or one fact about them determine whether or not they're jailed or what conditions they have when they're released. So we require judges to look at a lot of different factors, things like family, things like community ties and employment, when they're making these decisions about what conditions are appropriate. Perhaps most importantly, though, we put limits on what are called risk assessment tools. Risk assessment tools are algorithms and they're tools that are used by pretrial services officers to sort of determine, give a number value to the amount of risk someone poses. And they can be really, really problematic because what happens is what's being used to determine the ultimate number that gets spit out. So like in Chicago, there's a number 1 through 6 of your risk of new criminal activity and a number 1 through 6 of your risk of rearrest. I'm sorry, of your risk of not appearing in court. And the problem is that the information that's used to generate those numbers is information that has baked in racial bias, right? Because it's things like how many times have you been arrested? How many times have you failed to appear in court, which correlates with how many times you've been asked to appear in court, i.e. how often you've been arrested. And we know that with the way that our communities are over-policed, that creates huge problems. And it's just documented that Black people in particular have significantly higher risk assessment scores than white people do, even though there's no evidence, obviously, that there's some reason they pose more risk. And so it's incredibly important that we limit those tools. We created some limits so that basically the way that those tools work have to be made public, and defense attorneys have to have the ability to challenge what the tools say in court so that judges actually get a contrasting perspective from this number that sounds very official of like, oh, this is the level of risk that someone poses. We also require that judges basically don't use restrictive conditions of release unless it's the only way in their minds to prevent somebody from missing court or prevent someone from hurting somebody else. So this is a requirement that any pretrial condition be the least restrictive possible condition that can achieve that goal. This is really important. One of the biggest things, and we're going to talk about this at the end of the presentation, and maybe in a little bit right now, electronic monitoring is a huge problem in Cook County. So we have one of the largest pretrial electronic monitoring programs in the country. I think Houston just beat us out. This is not a race we want to be in. We do not want to be, I think we have about 4,000 people, between 3,000 and 4,000 people a day on electronic monitoring. Houston now has over 4,000, but again, second place is not good enough. That electronic monitoring is incredibly harmful. It's a form of incarceration. And so we require that judges make a finding that it is absolutely necessary. We also require that they review that finding every 60 days. We also make some changes that just modernize the way we think about how we treat people pre-trial. We ban drug testing, which there's no evidence that drug testing people pre-trial has any helpful effects of any kind. And we make restrictions about leaving the state optional instead of mandatory, because obviously, particularly for people who have family in Indiana, living in Chicago, leaving the state is not exactly a completely terrible thing to monitor in the age of cell phones and modern technology. No one is getting on a horse and riding off into the sunset in Utah, which is when that's what these rules are from, right? Is the idea that you don't want to flee. We also allow judges to give a grace period of 48 hours after somebody's missed court for them to be able to go in and actually address the problem instead of just issuing a warrant for their arrest. And that's incredibly important. We know that people miss court for the same reason that people miss all sorts of appointments, right? They don't have childcare, they have to work, they missed the bus, and so being able to say, okay, well, you have 48 hours, come in, explain your situation, and we're not going to take you into custody is incredibly important. As I said, we do provide more limits on electronic monitoring. We wish that we could have completely eliminated electronic monitoring, as we don't think it has any positive value. But we weren't able to do that, but we were able to put some limits on electronic monitoring. Judges have to reconsider it every 60 days. They have to let people out of their houses to do basic essential tasks like grocery shopping. That is currently not the law. So I used to be a defense attorney and I had a ton of clients on electronic monitoring. I like did people's laundry for them because they weren't allowed to get permission to go and do their laundry or go grocery shopping. So, as someone who just like knew them and had a car, I did that for them. That's a completely absurd way to treat people. So we require that kind of movement is allowed. We also prevent, there's a law in Illinois that allows a new class 3 felony charge if someone breaks the rules of electronic monitoring, which is an incredibly serious punishment. It's an extra 2 to 5 years in prison. We limit that slightly so that it can only be used if someone has been AWOL, sort of, not in compliance with the program for more than 48 hours. Currently, it is absolutely being used when people do things like take out their trash. People are being charged with class 3 felony escape. So we wanted to limit that. And the last thing is that we require that it be treated like incarceration. It is incarceration. People are incarcerated in their homes. And because of that, they should be getting credit as if they were in jail. And so the law requires that that's the case. These changes, and only these changes, the ones on this slide, actually go into effect in about 6 weeks. They go into effect in January of 2022. So we're going to have a full year of sort of seeing how they work before the rest of the bill goes into effect. We're super excited. I'm super excited for them to be in place because the amount of harm that electronic monitoring is currently causing is unfathomable, really. The scale of the problem is just immense. We also looked in the bill about what we do when people do violate pretrial conditions. So I talked about what happens when people violate EM, but of course you can violate your pretrial conditions in lots of ways. Missing court is a violation of pretrial conditions. Failing to report to your pretrial officer, getting arrested for something minor. And right now, when you're arrested for a violation, or when you commit something like what we call a technical violation, not showing up, doing something that isn't illegal, but is against the rules for you, like not meeting with your pretrial officer, you can be arrested and jailed all the way until you go to trial, which in Chicago can be months or years. It's almost always at least 4 months, usually 6 months, and it's sometimes over a year, 2 years if you're charged with a serious crime. So what we do is we ban the permanent revocation of pretrial release for most violations. Judges still have the ability to take people into custody, but it's capped at 30 days. So judges can't indefinitely incarcerate someone for like missing an appointment. We also create a fairer process for deciding whether or not filing a violation is appropriate. And we make sure that that only willful violations, like a judge makes a finding that somebody did this on purpose, only those can be punished by reincarceration or by another sanction. And then the last thing we did, and this is something that matters a lot to me as a policy expert, is we added sections to try and make pretrial practices more transparent and accountable. Right now, the state of Illinois pretrial data is terrible. Every county uses a different system. They don't talk to each other. A lot of counties don't collect information on really basic things like how many people go in and out of your jail every year. They just don't collect that information. And certainly it's not centralized anywhere. So there's a lot that we just don't know about what's going on around the state. So the bill creates a statewide data collection and publication process to make sure that everybody is using the same system to collect data, and it's actually collected in a way that the public can access and that we can actually look at. There's a working group on that has already started meeting. It's a huge task, but we luckily, because that part of the bill actually did go into effect a little while ago, there's a group that's working, and hopefully by the time we get to 2023, that process will be in place. So I just gave you a giant fire hose of information of everything about this bill. It's amazingly enough, I could probably go into more detail because, and see, I have a prop because my husband got this for me. This is the Pretrial Fairness Act. This is actually the whole Safety Act, but the pretrial fairness parts of it, or most of it, it's about the whole thing's about 700 pages long. The pretrial fairness portions are almost 400 pages of law. So I'm sorry for the huge fire hose, but I hope that I was able to at least give you a basic overview of what this looks like. Yeah, that format, my husband got that bound for me after we passed the law for my birthday, which was very nice of him. But now I just have this thing I can hold up and be like, see, it's really long. So I appreciate y'all bearing with me through some pretty, in the weeds policy stuff. I am going to pass it over to Dina to talk about sort of the big picture and some of the policy arguments, the arguments that are happening in the media about what's going to happen when the Pretrial Fairness Act goes into effect. Take it away.
Hey, that is a very adorable birthday present. I love it when you can tell that someone's partner really knows them. Cool. So I am Dina Rutherford. I am with the People's Lobby, which is a membership-based organization that works on a bunch of issues around race, class, and gender inequality, and tries to build a world via direct action and electoral politics and whatever else we got, where people on the planet are prioritized above corporate greed, and dismantling the mass incarceration system is definitely a big part of that. So my little corner of that effort during the passage of the PFA was that I ran our texting voter contact program. I am not a lawyer, but I have a lot of communications background, and I spent a lot of hours having conversations with random folks all over the state, which started to give me a sense of how people conceive of jail and safety, and how people, especially white, economically comfortable people, are raised to believe that a criminal is like a species of person that you are born being and can't stop being. So if you're in the system for any reason, that means you're bad and you deserve to be there. I feel a lot of fire and passion around trying to break down that narrative, which is why I was hyped about the opportunity to start helping give these presentations. So that's why I'm here. Okay, so Sarah and Akisha have spent some time laying out how the PFA affects people who are caught up in the system. And now we're going to talk about how it's going to affect everybody else in the community. And like Sarah said, take you through some of the opposition we're going to face as we implement this system over the next couple of years. Because, you know, the fight isn't over when the governor signs the bill and when Sarah's husband gives her a giant book with the bill written in it. We're still going to have to work to defend what we've won so that the tough on crime folks don't like take chunks out. So as we have discussed, there is no safety in a system where wealth determines who's in and who's out of jail. Personally, I believe that jail is more about making people feel like they are getting revenge on bad guys than it is about rehabilitating people and preventing crime. But as I've been doing voter contact about this, I try to make an effort to meet people where they're at. So when I have tried to flip this around on more conservative voters, I have made the point that if money bond lets you keep people in jail because they're poor, that also lets you let people out of jail if they're rich. One extremely timely example of this would be Kyle Rittenhouse, who everybody saw shoot a bunch of protesters, and yet he got out of jail immediately because him and his Trump MAGA people were able to just raise $2 million on GoFundMe. So one way that the PFA makes the community safer is by ensuring that a fair process determines who is free, not ransom. Reducing incarceration also reduces crime because the data shows that pretrial incarceration increases the likelihood that you will get arrested again. Jail sucks. It is an isolating, violent place that traumatizes people and yanks them out of whatever stability they had in their lives. Like, I am a middle-class white lady with a job and a house and a couple of cats. And like, if you plucked me off of my block and just dropped me in jail for a couple months with no warning, my life would be wrecked when I got out. Like, you can't just snip people out of all of their responsibilities and support systems and expect people to just be fine when they get back. People don't get help in jail. That's not what jail is for. And the shame and stigma and instability that it causes increases the likelihood that you will have contact with the criminal system, the criminal legal system again. You will definitely hear people tell you that reducing or eliminating money bail will cause people to skip their court dates. And this is just not true. As Sarah mentioned, what stops people from showing up for their court dates are the same things that stop us from being places we need to be sometimes. Like, maybe we couldn't find childcare or didn't have money for transportation or just forgot. Like, you don't need bail for that. You need a system that helps people get where they're going. No jurisdiction that has eliminated or significantly reduced money bond, including Cook County, has seen a resulting rise in crime. And if someone tells you that it has, they are wrong. Next slide, please. Thanks. Okay, so I'm going to take a step back here and then expand on my last point about how eliminating bond doesn't increase crime. So elected officials who want to sound tough on crime will talk about bail reform for people facing nonviolent charges, especially folks with drug charges. But our vision of pretrial freedom includes everyone. So it was important that we didn't leave people out who are accused of more serious things in this act. And we think it's important to explain why. For one thing, everyone deserves pretrial freedom, regardless of the accusations against them. None of these people have been convicted of a crime, and our legal system is founded on the principle that we are innocent until proven guilty. That applies to everyone. One mind-blowing conversation I had over and over when I was doing voter contact about this was that I would start explaining the like hundreds of thousands of people that get stuck in jail for years who haven't been convicted of anything just because they couldn't pay bond. And people would be like, wait, but we can't just keep people in jail who haven't been convicted of a crime. That would be very unfair. And I'm just like, yeah, I'm sorry for the Wikipedia journey you're about to go on, because it's really depressing. It's messed up. We need to wrestle with the discomfort that we have around releasing people charged with more serious crimes. Currently, we lock people up sometimes for years just because they were accused of something. And that is not how our system is supposed to work. This not only violates the principle of innocent until proven guilty, but it doesn't even make anybody any safer. As we talked about earlier, jailing people destabilizes their lives and makes it more likely that they will get arrested again. Just because a person has been accused of a crime doesn't mean they're a danger to their community. As you can see on this slide, after Cook County doubled the number of people released pretrial without paying any money, about 0.5% of the more than 30,000 people released in the last 2 years were accused of committing a violent crime while out on bond. Meanwhile, 99.4% of people successfully and safely just went back to their communities. Next slide, please. So we are all super hyped that we passed the PFA this year. This is a big deal, and it makes Illinois like the clear national leader in pretrial justice. But we know the fight isn't over, and there are a few things we know we're going to have to guard against. So one of those things is that before this new legislation is implemented, folks are going to try to make changes to it that would cause more people to be incarcerated rather than fewer. So opponents might want to drastically expand the detention net, which, as Sarah explained, is what we call the set of charges that qualify someone for pretrial incarceration. And it's important that we stand against this for all the reasons that we just discussed. Being charged with something more serious doesn't mean that you should automatically lose your right to pretrial freedom. The Pretrial Fairness Act ensures that, and we need to keep it intact. So now we're going to talk about the things that we're trying to guard against once the Pretrial Fairness Act goes into effect. Next slide, please. And please speak up if I'm talking too fast. I know that is totally a thing that I do. Okay, so Sarah went into this a bit, but I think it's worth recapping. What people mean by risk assessment tool is it's basically an algorithm that uses what we think we know about somebody to try to predict, Minority Report style, how likely they are to do crimes in the future. And we made these tools. The idea was that we would help judges filter out their own biases when making decisions by allowing them to like compare their assumptions to a thing that this robot said. The problem is that these tools are not any less biased than a human judge. For one thing, people write these algorithms and people have biases. So there you go, now the algorithms have biases. One sort of side example, one of the things that we do at the People's Lobby is organize gig workers. So like people who drive for Lyft and Uber. And a big article just came out showing that drivers who have non-American accents are like hugely more likely to be flagged by the system as bad drivers, which puts them in danger of being deactivated and like getting banned from doing that job anymore. Like a robot did that and it was still racist. So like just letting robots do it doesn't mean you have created a system that is immune to racism. Secondly, these tools are based on people's criminal records, which are inextricably tied to racist policing and the wider racist system that we all live in. The biggest predictor of how often someone comes into contact with cops in the legal system is their zip code. We should not base a person's access to freedom on the neighborhood that they live in. So as you can see from this slide, the PFA does significantly limit how these tools can be used, but we haven't eliminated them completely. They can be introduced at the state level or county by county, and the Illinois Supreme Court is trying to develop a statewide system. So we're going to need to keep fighting against the introduction of these algorithms that sort of allow us to feel like we are laundering our human biases into something that we can pretend is objective, but is not. Next slide, please. So as I mentioned, people don't actually need to be threatened and caged to show up to court. People are generally not looking to live their lives on the run from the law. What they need is resources, not surveillance and monitoring. So many false alternatives to incarceration are presented as sneaky side runs around actually reforming our pretrial justice system. And the forefront of these is electronic monitoring, or ankle bracelets, as they are commonly called. So the PFA has greatly expanded the rights of people on electronic monitoring. And I think the coalition is actually having an event on that in December, like a Know Your Rights event on those changes. But we suspect that the tough on crime crowd is going to react to the implementation of the PFA by trying to expand electronic monitoring once they can't throw as many people in jail as they're used to. So, you know, like Sarah was saying, if they can't put poor folks in jail, they will bring the jail to the poor folks and just imprison them where they live instead, which is like not that much of an improvement. Fortunately, the data collection that is mandated by the PFA will monitor how many people are on EM and also help us track when counties create new EM programs or try to expand the ones that they had. Oh, good question in the chat. The tough on crime crowd. I'm using that as a shorthand for like law enforcement groups like the FOP and also candidates for office who are trying to appeal to people who are really afraid of crime. Like if you have ever heard of Willie Horton, that was like an important historical example of this, of how like oh, thanks. Sorry for my million acronyms. It's really easy to manipulate people into voting for you if you promise to eliminate crime and keep people safe. If people aren't like willing to challenge what that vision of safety is, which a lot of times people aren't, it's easy to just make promises that you will get rid of all the bad guys and then you win votes that way. So those are the people who are interested in appearing to be against this. Okay. And we can get into this a little more in the FAQ. We actually do have a tool that you can use to thank people who voted for the PFA and scold people who voted against it. So what was I talking about? Data collection, right? So we need people to be working in their individual counties to oppose creating or expanding monitoring programs. If fewer people are in jail, that means the county is saving money, like they don't have to house these people anymore. So we need them to take that money and spend it on communities, not pour it into law enforcement or coming up with fun new ways of spying on people. So what we really want is a pretrial justice system that supports people as they're fighting their cases. So like Sarah was saying, right now, people on electronic monitoring can't buy groceries or go to the doctor without permission from the sheriff's office. And if they screw that up, they can be charged with a felony. That's not justice, that is a trap. We need to be giving people like bus passes and Uber rides and flexible scheduling in order to get them to court, and like connecting people with social services. But even with connecting people with social services, we don't want folks to use that as another way to have more control over people's lives. We don't want it to become a thing where like it's a condition of release that people show up to these meetings and then we can like punish and reincarcerate them if they miss a meeting with a caseworker. So that's a thing to watch out for. Next slide. Thanks. So now that the PFA has passed, many legislators who voted for it are facing heavy opposition from law enforcement and prosecutors and conservatives. We will drop a link in the chat. This is the little tool that I mentioned before, where you can thank legislators who voted for the PFA and be mad at the ones who didn't. If you put your address in there, it will point you to your particular legislator and also sort you into like, if your legislator voted for it, they will get a thank you. And if they voted against it, they will get a no thanks. You don't have to like do research on this to be able to help with this. And we've been told by our folks in Springfield that these messages do make a real difference. We have sent hundreds of them. You can also sign up for our newsletter at endmoneybond.org and follow us on social media for regular campaign updates. We also have some time to stick around for Q&A after this. If you have any more questions about information or resources about any of these ideas. And yeah, please just spread the word. We need a lot of support to stand our ground for this law as it goes into effect over the next couple of years. Next slide. That's it. Thanks for coming. Any questions?
I have one thing to add about that is specifically for the League of Women Voters of Evanston about what is the most important thing you can do to help us out. If you look at what happened in the last election, the people who are falling for tough on crime rhetoric, meaning the people who are voting for politicians who oppose bond reform, are voting for politicians who claim they're going to be able to get tough on crime, are white suburban women. That's who they are. They're suburban women. So, you know, I think a lot of times we think of ourselves as, I'm a white urban woman, but I grew up in the suburbs. We think of ourselves as like not being connected to people who need to be convinced of something. Like we sort of feel like we're in an echo chamber. You are not in an echo chamber. You think you are, but you're not. The people around you, particularly women, and particularly in the suburbs, are exactly the kind of people who need to hear about this law and why it's good. So I think that that's something that I just always like to highlight in this group in particular, because I fall into that trap too of thinking, oh well, everyone I talk to agrees with me, and it's almost certainly not true, whether or not they're telling you. So please help us spread the word. And with that, I'll stop sharing so you can actually see each other and we can answer any questions anybody has.
Okay. Thanks so much for the wonderful presentation, just full of information. And looking at your book, perhaps there's even more information, but we'll say that for another time. And your reminder that we take on our role as trying to educate our members in our communities about important issues. We'll keep that in mind, and we'll keep working on that in this area. One of the questions that relates to what we heard about that matter of education and people's attitudes, and I'm thinking about the judges. You mentioned in various ways that some judges have biases. They use these assessment tools. The assessment tools might have biases. And actually, we've heard from, I think, Judge Evans and other judges, it's our right as judges to put people in jail if we want to. The legislature doesn't have the ability to limit that right. So, in any case, this is a new situation, so judges need to be trained. And is there a process that's taking place to make sure that judges are going to be following this new law?
Right into it. Yes, particularly in Cook County. So thankfully, because yeah, it's very important. One of the benefits we have in Cook County is that all of our court stakeholders are supportive of ending money bail. Even the sheriff is supportive of ending money bail and has been for a long time. Is he supportive of every single thing that's in this bill? Probably not. But we all agree. There's a lot of stuff we sort of do institutionally agree on in Cook County, but there's also a lot of training that needs to be done. So there's a working group system that's been started. There are a lot of people doing a great job of pulling together the various sort of system stakeholders who all need to talk. And what I'm really excited about, because often this doesn't happen, is they are bringing us in. So policy experts, people who wrote the bill, people who have been directly impacted are getting a voice at those tables, which in Cook County is really good news. Because it does not always go that way at all. In fact, I can't think of a time in my career with a reform that it has gone that way. So I'm very encouraged by the way that the county is approaching this. although it is going to require a lot of constant vigilance on our part to make sure that this information actually gets to judges. That would be my answer to that.
And what about the rest of the state?
Oh, good question. There is work being done. The Administrative Office of the Illinois Courts is doing a lot to try and figure out where each county is actually at right now in their pretrial system. Every county operates so differently that it's going to have to be a county by county approach. So AOIC is doing a lot of the coordination for that. Hopefully that it will get started in earnest in January, and it's scheduled to, which is good because we only have a year. So it is one of the reasons why we had the delayed effective date and didn't have the bill go into effect immediately, because we knew that it was going to take time to make this right, because it's a really huge change in the way that judges are going to do their jobs.
I'll just also remind people that our speakers are putting information in the chat box as well, adding to what they said. So be sure and look at that. So
question from Diane Goldring.
I do. Thank you. I know we're at time limit, so I'm trying to ask this quickly. So you had a statistic, Dina, that you put up, like I think it was 99.4% of the people who are out do not commit violent crimes but the 0.6 who do seem to get just an inordinate amount of attention. So how do you counter that?
Well, one thing, so the thing that I found most challenging about talking to folks about this issue was when I would run into someone who was like, my sister was murdered. What do you have for me? Because like, that's awful. Obviously, I'm not going to tell someone that their sister doesn't count. Like that is thorny. And I asked, I think it was maybe actually Sarah, I asked like, what is the best way to handle this? And the advice that I got was like, at least with the PFA, when someone gets released, there is a process for it. Like people who may have been the victim of this person get notified in some way that this is about to happen so that they can brace for it. And they are being released because for whatever reason, a judge thought that they would not cause more damage. Obviously that's not 100%, that doesn't work 100% of the time, but the alternative is letting someone out just because they paid to be let out. So that's not better, you know? Sarah, was that a decent explanation?
Yeah, no, I think you're right. I think, especially when someone's directly attacking the switch away from money bond, we act as if we're comparing a new system to a system that actually works, and we're not. We're comparing it to a system that doesn't work, right? So, so I think that's important to note. But I think in terms of the safety conversation, one of the things that we were able to do in this bill that, again, no one else in the country has done is that this bill was supported by all of the major domestic violence groups that represent victims, as well as the Chicago Alliance Against Sexual Exploitation, which represents sexual assault victims. And the reason we were able to do that is because we worked with them and talked to them about what we need to do and how the system needs to work to give victims and survivors what they need during the pretrial process, right? And it was a lot of work to find that common ground, but we did. And so I think one thing that I always tell people is, first of all, we can't make our decisions about what policy we're going to have by looking at one case or the worst case. I went to law school, and like one of the things that they tell you it's like the first thing anybody tells you in law school is hard cases make bad law, meaning the things that the thorniest issues are the ones that cause us to react and slam down and say, okay, well now we have to incarcerate everybody because something has happened. We cannot stop all crime. We cannot stop all crime committed by any group of people, and that includes people released pre-trial. It's just not possible. And if it were possible, it certainly wouldn't be through incarceration. It would be through a very, very different approach to what community safety and funding and resources meant, right? It's not going to happen because we jailed people. So I think that's really something to focus on, is to say, what has happened here is terrible. First of all, also, I would also note, whenever this does come up in the paper, it is always accusations, and they don't always follow through to see if those cases stick, which as a former lawyer drives me crazy, because a lot of times they don't. So that's just one thing. But I think you also have to note, we need to look at the whole picture. When we did the first step of bond reform in Cook County, and which eventually led to us decreasing the jail population by about 5,000 people, from what we heard from law enforcement and other groups, you would have thought the sky was going to fall down around us and we were going to descend into lawless chaos. And we did not. It just didn't happen. Okay, that change happened in 2017. Crime fell consistently during the time that it was in place. Even now, everyone's going to tell you that crime is up. Please remember that some crime is up, but not all crime is up. So murders are up, but robberies, sexual assaults, burglaries are down. So crime is actually continuing to fall during these reforms, the majority of crime. So, we really have to pay attention to the bigger picture. And that was a very long answer to your question, sorry.
Another question, you use the term community safety, which I think is a good term. And you talked about people missing court dates, and often just for sort of everyday reasons, not because they were willfully avoiding court. I think maybe you mentioned just in passing, using the funds that we weren't paying to keep people in jail to provide services to help them stay out of jail. Can you talk more about these services helping to keep people out of jail, and what's in the new bill that helps that, or is that the next step? What's the situation there?
I'll let Akisha take that one.
Hey, that's a good question. So one of the things being proposed are like alternatives to incarceration into the Cook County budget for 2022. One of the ones that most aligns with this, though, is the alternative towards 911 for mental health emergencies and other substance abuse emergencies. That way, they originally won't even be put into the CAR system in the first place, because we know some of the most vulnerable people in that pretrial holding time are those who have outside concerns and barriers. Other ones are like stopping the pipeline in the first place, right? So we ask people like, what put you down this road in the first place? They're going to mention things that are about gaps in resources, gaps in education, gaps to stable housing. And those proposals focus on those things as well. But are those in the actual bill? These are alternatives that these are new ideas that are coming to capture the money that will be recouped from the bond reform.
I will just note, the jail population has dropped by 5,000 people since 2017, and the sheriff's budget has gone up. So we are currently not doing a very good job in Cook County of successfully transferring funds that we are saving into communities. We need to do better. And I know that Soul is and People's Lobby both are involved in, and Appleseed actually are involved in the budget for Black Lives, which is a whole platform of redistribution.
And if you all want to be involved in pushing, because this is the commissioner level thing, if you're going to be involved in pushing your commissioners on this, I can send you all the proposal after this if you all would like. Yeah, I'm going to drop
Going back to what Sarah said, isn't some of that money going into electronic monitoring, and the number of people in jail has dropped and the number of people on EM has gone way up? And is that directly addressed in the bill, or is that part of the next stage?
So yeah, the bill doesn't have money involved. The bill doesn't deal with money. It doesn't deal with funding things. It doesn't deal with cutting things. From a political perspective, that was very important because everyone has different opinions about how that needs to happen. A lot of that is being discussed in implementation. But really, the systems that our criminal justice systems in Illinois are mostly county level. So, at the state level, there really wasn't sort of a big overarching thing that was obvious to do that would like fix it all over the state. So it is really, as Akisha said, it really is a county level and commissioner level effort that's going to need to happen in 102 counties. And that will be the work of the next probably quite long time.
Wow, I mean, that's interesting. It is an ongoing job, isn't it?
Mm-hmm. Really, passing the bill was just the beginning. The real work of getting it actually implemented the way it's supposed to is huge. And I think we've made good strides on it. If there's someone, our friend.
Well, that gives us a lot to think about. Are there any other questions for our experts?
Oh, there was a question in the chat that I said we would loop around to, which was, who should get credit for this law? My initial response was like, I don't know how I would possibly try to figure out how to distribute credit among the literal hundreds of people that worked to make this law happen over the last bunch of years, but maybe Sarah or Akisha have a better answer.
Yeah, I mean, here's what I will say. The thing that made us different than other states was our organizing and our organizers. I'm the nerd. I'm the policy nerd in the coalition, one of them. I help write the legislation. Can someone mute friend for here?
Thank you very much.
So we can, the coalition dates back, about almost a decade now. The groups that got the bill passed is if you want the list of organizations, I can give it to you. The list of organizations in the coalition and money bonds are on our website, and it's a very specific list of people. Those are the organizations that put the names in. In terms of people, not orgs, I mean, that's not really fair. I think, frankly, I'll be honest with you, there absolutely was not one person or even 100 people who could be named that got this bill passed. This was the work of thousands of people over years. And the people who organized them obviously are people who are still doing that work and were still involved. But what we really need, honestly, to pay attention to is how do we get even more people involved? Like this is it's a movement, it's not a moment. And we really but I do think that like the thing that I would emphasize is that this was a grassroots movement in the most traditional sense. We actually surprised the heck out of most of the national policy community by getting this done because they were not super involved because this was such a grassroots movement. And that's where the credit goes, and that's how this movement should be talked about.
Well, I do kind of feel your frustration that like the way this often ends up in the mainstream media is that, a picture of JB Pritzker signing the law.
Hell yeah.
It's like Pritzker passes law that fixes problem is like not a comprehensive way to describe what happened either. So I get why you're like a little frustrated about it. But yeah, that's just not really how organizing works.
When the law passed, I mean, the initial response from the Tribune at least was, wow, this just came out of nowhere. All of a sudden, late night process, they passed this law. And
you're not getting me started.
Yeah, organizers are permanently cranky about that. That is just how it always goes, and everyone is always salty about it, and that's life. Like so many things, the truth is longer and more complicated, and so it's hard to get it out.
Yeah, there's been a version of this bill in the legislature since 2017. Everyone had plenty of time to read it.
Yeah. Maybe you could just clarify something for me before we end. I think this is a wonderful achievement. But when we look at criminal justice reform that was passed this year in Illinois, it included more than just pretrial fairness, right?
Yes.
Mm-hmm. Okay.
Yeah, and there's a real sort of bunch of different policing reforms that are also in the Safety Act and a couple other things. But the Pretrial Fairness Act is, I would say,
a big part of it.
It's sort of the big cohesive part of the bill that was all passed as like, this is our big reform idea that's gonna carry us forward. I think, frankly, for policing, we are still waiting for something that sort of comprehensive. A lot of what was in the Safety Act was important, but was relatively small changes around the edges to the way policing works.
Okay, thank you.
Yeah, I mean, I guess, you know, thank you all so much for giving us this presentation. I mean, this is a very complex topic. You know, there's so many aspects to it, and this, you know, ending cash bail is a very visible one, and it's gotten a lot of attention, but it's only part of a bigger process. And you know, as we looked into it last year, and as you know, there's been discussions in the national media, you know, this whole criminal justice system, you know, has so many elements to it, and it's really important that, you know, to take this step in Illinois, and it'll be interesting to see. I mean, I think other states may be, you know, inspired to follow through, but there's still a lot to do, and the work that you and your organizations are doing is so important. And you know, I think as far as the League of Women Voters is concerned, you know, we're really glad to have the opportunity to be better informed about this important issue, and maybe be inspired to follow and support the work that you're doing. So unless there's another question, thank you so much for joining us.
Thank you for having us. Really
yeah, well,
appreciate
you
it.
know, it's so important for us to learn more. So thank you for all your good work, and we'll keep paying attention to this. So thank you.